right, so I hope this is it. Good day, everyone. I am Mark Su, and if you're watching this, it means that you are with me and sabay nating aaralin ang law on partnership. So, to start with, let us understand the tri-level existence of partnership. For me, this is the most fundamental note in understanding partnership in itself. The objective, the concept of its existence, and also the uh, legal hermeneutics of partnership in itself, on why we should study it and why it is essential in the lives of the businessman, for instance. So, partnership exists according to scholars because of these three reasons. One, as a contractual relationship. Two, as a medium of doing business. And three, to pursue a going concern. So one by one, we will discuss that later on. First, let us understand the existence of partnership as a contractual relationship. So when we speak of a contractual relationship, this refers to relationship as to the partners themselves. So remember that when we speak of partnership, hindi lang po yan siya automatically dalawang partner like X and Y. So X and Y alone can be partners? No. In the legal sense, partnership may refer to more than one or more than two individuals. So ganun po siya. It is not in its literal sense na sasabihin natin na partners, it is only exclusive to two persons. But when we speak of a partnership in legal terminology, it is not exclusive to two persons. So Article 1767 of the new Civil Code provides for the definition of partnership. So you can see there in your screen what is the definition of partnership. So in order to understand this, you have to remember the essential the essential concepts or key points of Article 1767. So you have to remember that two or more persons must contribute. So there is a contribution in order to make a common fund. And the intention of making a common fund is to later on earn a profit and divide such profit among themselves. Okay? So that is actually a partnership talking about pursuing a business. In the second paragraph, we're talking about partnership by profession. So the law contemplates that two or more persons may also organize a partnership to exercise a profession. So this is actually essential. You have to take note, or all of us must take note, Article 1767, because it is the prime definition of partnership. Remember that two or more persons bind themselves to contribute money, industry to a common fund with the intention to divide the profit among themselves. So tandaan po natin ang mga elements na yon ng contract of partnership. Next, what does Article 1770 provide? So we have to note that even if we comply the elements of a contract of partnership, which are number one, that two or more persons come together and bind themselves to, number two, contribute funds, property, or industry. And number three, with the intention to divide the profits among themselves, even if these essential elements are present. But the objective of the purpose of such contract of partnership being established between and among the parties is not lawful, is not within the ambit of the law, then still we cannot warrant a valid contract of partnership. Now, let me provide an example in order to make this one clear. So, halimbawa, si X at saka si Y, they are rich individuals, mayayaman sila. So, ngayon, dahil nakita nila that when the pandemic struck their community, nakita nila na maraming na-lay off sa mga trabaho, marami ang nahihirapan because, ayun nga, walang makain, walang pambili ng gamot. So, because of that, they decided to contribute money. So, ayun. Nag-business sila. And out doon sa money na na-contribute nila, nag-business sila. Tapos, yung proceeds noon or yung kinita nila sa business nila, dinonate nila doon sa kanilang mga kababayan na nahihirapan. Now, let me ask you a question. Is there a valid contract of partnership between X and Y? So, in order to answer that, let us go back to our Article 1767. So, two or more persons bind themselves. So, yun, si X and Y, present, tama yun. To contribute money, property, or industry. In the present problem, ano ang kinontribute ni X and Y? Pera yun, hindi ba? Nag-contribute sila ng pera in order to build a business. Pero, the last element is not present here. Bakit? Because X and Y have no intention to divide the profit among themselves. What did they do to the profit? Ang ginawa po nila is, dinonate po nila yung kanilang kita doon sa kanilang mga kababayan. So, in that sense, walang contract of partnership between X and Y. Okay? Tandaan po ninyo, walang contract of partnership. Why? Because walang intention to divide the profit among themselves. Ngayon, how about sa another example wherein sabihin natin si A and B contributed a money, say for example, 100,000 each silang dalawa to build a business. Sabihin na natin sari-sari store. Pagkatapos, yung proceeds nila, hinati nila sa kanilang dalawa. Kasi gusto nila na magkaroon ng extra kita because sa hirap ng panahon, hindi nakakaya ng kanilang sahod yung kanilang expenses. Ngayon, kumita sila, hinati nila yung kita nila sa mga sarili nila, and then, ayun, magkaroon sila ng maginhawang pamumuhay because of the additional income. So, in the second example, there is a valid contract of partnership. Why? Because we test it using the presence of the elements of contract of partnership. First, two or more persons bind themselves. So, itong si A and B naman, merong kapasidad na to enter into contract. So, tama yun. Check ng first element. Second, they contributed a money. Dito, money pa din ang kinontribute. So, pinatayo nila ng negosyo yung money na na-contribute nila, and later on, they divide. This is the last element natin na wala doon sa isang example. But now, in this case, they divided the profit within themselves in order to have additional income to supplement their livelihood expenses. So, with that being said, all three elements are present. There is a valid contract of partnership. Ngayon naman, on the third, dito sa ating third example, sabihin natin, si Juan and Pedro. So, Juan and Pedro engaged in a contract of partnership wherein they contributed 100,000 pesos each, and they used that money being contributed to a common fund to purchase illegal drugs. Ayun po ang ginawa ni Juan and Pedro. They purchased illegal drugs and sell them to potential customers. So, in order to determine whether or not there is a valid contract of partnership, let us try to look for the elements of such contract. Two or more persons bind themselves, Juan and Pedro, check. Contributed money to a common fund. They contributed 100,000 pesos, check. And later on, divide the profit within themselves. Oh, ayun na. Nung kumita sila dahil marami silang nabenta, yung 200,000 pesos nila naging 2 million, hinati nila yung 2 million sa kanilang dalawa. So present yung tatlong element natin. Question: can there be a valid contract of partnership here? The answer can be found based on Article 1771. Article 1770. So according to Article 1770, in a contract of partnership, there must be a lawful object or purpose. So in this case, the purpose of the contract of partnership between Juan and Pedro is not lawful. We have to keep in mind that selling illegal drugs is punishable under the special penal law, no? Yung ating Article 9165 or the Dangerous Drugs Act of 2002. So that being said, there is an existing law punishing the act of selling illegal drugs. So therefore, it cannot be lawful to establish a partnership in order to pursue a business enterprise pertaining to drugs. So ganun po. What am I trying to point out here is that the test to determine whether or not there is a valid contract of partnership is not actually solely lodged on to the presence of the elements of the contract. You must as well take into consideration the purpose of that partnership in itself in order whether or not we can warrant a valid existence of partnership. Okay? Now, how about Article 1771? According to Article 1771, a partnership may be constituted in any form except kung meron ng mga real properties or real rights involved. Now, first, partnership can be constituted in any form. Ibig sabihin nito, walang definite or walang required form on how a partnership is to be constituted. Kung wala kayong written agreement, pero kompleto naman yung presence ng tatlong elements, pwedeng may contract of partnership basta lawful ang purpose. Or kung meron kayong written agreement pero nakasulat sa 1/4 sheet of paper, present ang tatlong elements ng contract, lawful ang purpose ng partnership, still meron pa ring contract of partnership among you. So walang pinagkaiba kung meron kang notarized na contract of partnership. Kompleto yung elements ng contract, lawful ang purpose. Doon sa oral agreement lang, walang papel, pero kompleto din yung elements ng contract of partnership, lawful ang purpose. Walang pinagkaiba yun. Pareho pa rin may contract of partnership. There lies the difference, however, kung doon sa inyong partnership, meron ng real property involved. Anong example nito? Example number 1. Halimbawa, ang kinontribute ni sabihin natin, dito sa bagong example natin si Marie at saka si Juana. For example, itong si Marie, ang kinontribute niya is 10 hectares of land. And ito namang si Juana, ang kinontribute niya is 100,000 pesos. So, because there is a real property involved, which is the land, then doon na magkakaroon ng required form on how to constitute partnership, which is in written form. Kailangan, it should be executed not just in written, na isulat mo sa 1/4 sheet of paper or kaya ilalupad, tapos permahan mo, kaya bond paper, no. Aside from being in a written form, it has to be executed through a public instrument. What does it mean when we speak of public instrument? It refers to notarized documents. So, ibig sabihin, punta ka sa abogado, execute kayo ng contract of partnership, nakasa doon na ang kinontribute ng kapartner mo is lupa or real property or any form of real property, bahay man yan, lupa man yan, or anything contemplated by law as real property. Kasi kailangan yun. Kasi yun ang nakasaad sa Article 1771. So now, we have already understood the elements of contract of partnership, the purpose of contract of partnership, the form of contract of partnership. Let us dig deep on when the partnership should begin. And the answer can be found in Article 1784 of the New Civil Code. The partnership begins from the moment of the execution of the contract unless it is otherwise stipulated. So, how do we understand this? Ibig sabihin, kapag nag-enter into partnership kayo, so the moment that you have fully executed your contract, that is also the inception of the partnership, the existence of the partnership. Pero, kung doon sa contractual stipulation ninyo, nakasaad doon na magkakaroon ng partnership between A and B and the life or the existence of this partnership begins next year. So kung ano yung nakasaad doon, yun ang masusunod. Okay? That is the determining period as to where the partnership begins. So before we move on to our next topic, I would just like to point out keynotes. First, earlier, we spoke about Article 1770 and 1771. So in Article 1770, we have doctrine by incorporation of law. You have to remember that in every contract, all laws must be incorporated. Kaya hindi ka pwedeng gumawa ng kontrata na illegal. Hindi ka pwedeng gumawa ng kontrata na merong violation sa batas. Kasi under the doctrine by incorporation of laws, lahat ng kontrata nakapaloob din doon ang lahat ng batas na umiiral sa ating bansa. So, if you can remember in an earlier example, the contract of partnership is not valid even though all elements are present kasi hindi lawful yung purpose niya. That is contrary to law. Under Article 1771, the doctrine there is doctrine of consensuality. Okay? So, ibig sabihin doon, kapag nagkasundo kayo na mayroong contract of partnership, whether or not walang form or walang anong written document dyan, whether oral agreement lang for as long as you have complied to the elements set forth by law, ibig sabihin nun, valid ang contract of partnership ninyo. Okay? Don't forget that. Let us all remember that. Next, partnership exists as a medium of doing business. Okay. So when we speak of this one, we refer to the partnership having a separate juridical personality. Now, before we proceed discussing this, let us all understand the personality contemplated by law. So there are two personalities contemplated by law. Under the New Civil Code of the Philippines, we have natural personalities or natural persons. Ito po sila yung mga persons created by God. O yung mga tao. Ako, ikaw, human beings. These are natural persons. And yung persons created by law or the juridical persons as we speak. Ngayon, itong juridical persons, they are not actually or persons created by law or the juridical persons, they are not actual persons wherein they have feelings, they have heart beating inside their chest, they don't have brains. They are actually corporations or partnerships or other entities which the law created for them to have a separate personality from the person controlling them. Halimbawa, kagaya si SM Mall of Jensen. Si SM Mall of Jensen at saka yung may-ari ng SM Mall of Jensen is they are not considered as one and the same person. SM is a different person from the persons owning it. Okay? Later on, we will understand more to that. So, the following under Article 44, the following are juridical persons. Nakalagay dito, corporations, partnership, and associations for private interest or purpose for which the law grants them juridical personality. Ayun na nga ang sinasabi ko kanina. Partnership has a separate juridical personality as well as corporation, as well as non-governmental organization for private matters. Yun, meron silang separate juridical entity. So, nakalagay din dito sa Article 1768 ng New Civil Code that the partnership has a separate and juridical personality from its partners or from the persons controlling the partnership. So, let me give you an example in order to understand this in a clearer situation or in a clearer perspective. Halimbawa, itong si A and B, nagkaroon sila ng partnership. Tapos ngayon, sa partnership nila, ang negosyo nila is bigasan. Ngayon, nung bumili na yung kanilang, halimbawa, ang tawag sa kanilang negosyo is AB Bigasan Partnership. Ganun ang tawag, AB Bigasan Partnership. Ngayon naman, itong si AB Bigasan Partnership, hindi nakabayad doon sa kanyang supplier, which is si XYZ supplier. Ngayon, itong si AB Bigasan Partnership, dahil may pagkakautang siya kay XYZ supplier, kinasuhan ngayon ni XYZ supplier. Sino ang kakasuhan ni XYZ supplier? Is it the individuals A and B or the partnership AB Bigasan Partnership? The answer to that is the latter. Since AB Bigasan Partnership has a separate juridical personality from its owners A and B. Hindi mo pwedeng kasuhan diretso si A and B. Ang kakasuhan mo is the partnership. Since the juridical personality of partnership is given under Article 44 and the separation of juridical personality from its partners is vested or provided under Article 1768. Now, ito namang nakasaad sa Article 45 ng New Civil Code is partnership daw is governed by this code. So, pati rin daw yung corporation. Pero actually, now, ang corporation is meron na siyang separate law governing the corporation code. Na-repeal na po yung corporation, yung provisions on corporation under the New Civil Code. So, ayun na nga, when you have separate juridical personality under Article 46, you can acquire property. So, si AB Bigasan Partnership, pwede siyang bumili ng property niya, pwede siyang mag-file ng kaso against doon sa ibang mga tao as a separate personality from its owners. So, now, let us talk about pursuing a going concern. This is the last fundamental concept on the understanding of partnership's existence. So partnership exists to pursue a going concern. What is a going concern actually? So a going concern under the discipline of economics and accounting is also referring to business enterprise. So ito may sinabi ang Supreme Court natin tungkol sa going concern or business enterprise. So, sabi dito, ang partnership daw, or we can appreciate more the concept of partnership through its business enterprise. We associate kasi business enterprise more to the operation side of partnership. Kanina kasi na pag-usapan natin, lahat yun is legal matter. Lahat yun are legal matters. Pero itong going concern, ito ay tumutukoy doon sa business aspect, like the operation, who will handle the um, sales force or advertising, paano ipo-push through yung um, uh, purpose talaga on why partnership is being established. Kaya may mga mission, vision, and goals tayo sa ating mga companies that pertains to actually the going concern. So when we speak of going concern, it talks about, kagaya nga dito, business enterprise, and business enterprise refers to actually the um, operative function of the business itself. This actually parang um, hindi na siya gaanong doon sa legal matter, kundi doon na siya sa business side. So, in summary, I hope you understand the tri-level existence of partnership. Partnership exists as a contractual relationship between and among partners. Partnership exists as a medium of doing business with a separate juridical personality from the partners, and partnership exists to pursue a going concern. Thank you so much for watching this video. I hope na this is helpful. And if you think this is not helpful, just let me know in the comment section so that I would know how to improve my future contents. Ciao!